Hi, I'm Bob Schock. Welcome to my show.
Bob, I understand you take on civil rights cases.
Absolutely. Same as I take on personal injury cases, products liability, medical malpractice cases. I represent the individuals against a governmental agency or against a hospital or against a major corporation, generally.
Now, I've always thought, as an African American person, that a violation of my civil rights is if someone calls me a name or something, or they treat me inappropriately in a public place or a private place, or does it matter? Am I off base?
You're a bit off base. That may be bad politics, politically incorrect and all those things, but that doesn't rise to the level of a violation of civil rights. A violation of civil rights has to affect you personally. If the name calling includes a threat of bodily harm, then
it's a hate crime.
You move it into either a hate crime or a civil rights. You've got federal statutes, 1983 and others, that protect people from being harassed and so forth by other persons. There's also state law under the Civil Code, the Unruh Act, that also protects people from not just words, which are quite enough, but threats and actions that deprive a person of their civil rights.
Do civil rights also extend to sexual harassment cases?
Absolutely. That's another section of the federal law and the state law. That's not on-the-job sexual harassment, but you still have to distinguish sexual harassment that is not on the job with that which is on the job. If it's on the job, it's a violation. Sexual harassment directly, generally, is by two independent individuals, is generally not a civil rights violation.
We mean, for example, give me an example of sexual harassment not on the job, since we generally hear cases on the job.
Okay, you take it, let's make it a female who works, she goes to a workout place. She goes to a gymnasium to work out, and there are males or others that constantly are making suggestive comments. That may or may not be a violation of her civil rights, and probably isn't if there's no real threats. She would then have to figure out a way to tell the gymnasium that they need to regulate people and their actions and kick them out because they're providing a place where she can be sexually harassed. So that's the type of issue. The individual who doesn't have any relationship to the club is not going to predicate a cause of action against the club. So that's the basic issues.
Interesting. How often do you get a call to take on such cases?
We probably get one or more a day. So we probably are running 300 potential civil rights cases a year. We probably take 5 to 10. Most of the civil rights actions can be resolved through filing complaints with the FEHA or the EEOC or through some other manner in which they don't need to have an attorney. I only come into it when all other potential remedies are exhausted. Now, we have to be fairly selective on what we take to make sure that we're not spending a lot of time and wasting people's time on a case that is not viable and is going to end up being dismissed by a judge.
Right. Hence your consultation period, right?
Correct.
Yeah. Are there more complaints of this nature now than there were, say, 5 or 10 or 15 years ago?
Yes. I think people recognize that they do have rights more so nowadays than 10 or 15 years ago. Many things that were going on 10, 15 years ago, people did not realize they could go to an attorney or could go to a governmental agency, and they just accepted things. Today, I think people are more cognizant of what their rights are. By the way, civil rights is merely the right to live without being harassed, threatened, and adversely affected in your day-to-day living. It's the civil right of anyone to live a life without that.
But you're saying in the case of the gym that guys can't go over and say, hey, you look great anymore, right?
An isolated instance like that, of course, is not a violation of anything. And if you did it 10 times, it's still not a violation against that person. What you would have to do is try and say
So the
that
single male is saved.
for the moment, yes. For the moment, yes. Or vice versa. I mean, it can go either way. There's cases that have gone both ways.
Yeah.
Where a individual male has been violated because of a female supervisor or something else who's requiring sexual favors. So it goes both ways.
Okay, but that's, wow, okay, interesting. That's at the workplace, right?
That's correct.
As opposed to at the gym.
Now remember, if the individuals who are involved at the gym probably can't be sued, who are doing the harassing, it's back to getting some kind of a platform on which to say that you have a contractual relationship with a gym or with an employer, and they owe you a duty to protect your rights.
Or even at the gym if it's a guy to guy, because there are a lot of, I look at Craigslist, there's always these, guy meets another guy or sees another guy at the gym and all this sort of thing, you know.
Same thing. It applies equally to everyone and all persuasions.
Interesting. Interesting. Is there a idea that sometimes some complaints are frivolous versus serious? In other words, there are some people who contend that the law is sometimes used just for a person to enact a personal vendetta against somebody else.
Well, I think you have to look at it on an individual basis. I think the courts are loath to allow the maintenance of a civil rights action that involves a couple of inappropriate acts or statements. They don't want the courts clogged with it, and they don't think that's a large enough problem to warrant judicial intervention. Conversely, when the harassment, or whatever you want to call it, reaches the point to where it is producing a serious effect, that's when the courts are taking notice and allowing these cases to proceed.
If I'm a woman and I'm actually a member of 2 professional women's groups, is there a test that I should apply for when I know something has gone too far, or as opposed to leaving it to my personal whim or emotions?
No, I think if you think it's gone too far, then you seek counsel. And find out if under the law that is in existence at that time there is a viable cause of action against the responsible parties. Absolutely.
Is there anything one should do in terms of recording notes or taking information or having, producing a body of evidence?
Absolutely. Obviously, when anyone thinks they're starting to be harassed, they need to keep meticulous notes of everything that's said, the dates, the times, whether there's witnesses. One of the most important parts of these cases is the corroborating witness. Because if it ends up being he said, she said, those usually go down the tubes. It has to be he said, she said, and an independent party or other people saw.
Or in today's world, she said, or he said, or something like that, right?
Well, let's switch it over to brutality or police brutality.
Okay.
In 90% of the cases where you have a potential police brutality case, if it's only the person being arrested's word against the police, which would be 2 or 3 police officers, it's virtually impossible to win the case. Conversely, if the same conduct has happened, and there's been cases, one of which was in San Francisco, where a doctor, I think, African-American doctor, was in an altercation, in effect, not his choosing, with the police department, and was beaten up by the police, he probably still would have lost, except there happened to be observers who saw what was happening and could testify, and in that case, a substantial jury award came up.
And I think there was in Shreveport, Louisiana, a case of a woman who was incarcerated, or at least taken into custody by an officer who then slapped her to the ground and then turned off the surveillance video and then after the surveillance video was reactivated, it was obvious that she was black and blue.
I don't recall that one, but that's not atypical. That there are a number of cases like that. And of course, you've seen where people now, with everyone with these camcorders and videos, where somebody makes an arrest, there's a video showing exactly what did take place, which generally or often differs with the official version of what allegedly transpired.
Do you advocate that everyone carries a camera or use their cell phone appropriately?
Sure. I think that's an effective thing, although I understand that a lot of times the police department will take the phones.
Is that legal?
No. I'm just...
Yeah.
They can do that, but no, it's effectively, the effective thing is to have a third party doing it while you're defending yourself. I'm talking about a brutality case where the police are actually using more force than reasonably necessary to do whatever they're doing. The difficult situations rise because most of the apprehensions involve someone who probably has participated in some kind of illegal conduct, whether it's a misdemeanor, a DUI, or something like that. So from a jury's standpoint, they're looking at someone who's probably done something a little wrong against a police department that allegedly has done nothing wrong. So that gets a little difficult. That's why the third-party cam or video or just as a witness who can corroborate that that person did not use excessive force against the police officer or officers or use any force at all, and it was all one-sided by the police. That's what's very important.
So to close, the important matters to remember in our conversation are, if you believe you are experiencing harassment, first of all, gather evidence.
Absolutely. You have to make a case.
Second of all, make sure you have a witness or witnesses.
Excellent.
And third, seek counsel.
Absolutely.
Excellent.
All three, but you need your witness and your everything written down first, if possible. I'm not saying it's impossible to handle the case if you don't have that, but it makes the job that much more difficult.
And they should, of course, call you.
Absolutely.
Yeah. Thanks, Bob.
Thank you. This is Bob Shop, the Oakland personal injury attorney. View it. Have a case that you'd like reviewed, we'd be happy to review it at no charge to you to determine whether we feel that we can help you attain a better settlement, a better result, or reach justice.